wrap up. I recognize Mr. Edlow to please begin his opening statement.
Thank you, sir. Chairman Comer, Ranking Member Raskin, and distinguished members of this committee, thank you for the opportunity to present testimony today regarding the regulatory and policymaking efforts that have directly undermined U.S. immigration law, triggering a crisis of epic proportions. Using a cadre of intentional mechanisms, the Biden administration has waged war against the immigration system of the United States. Beginning on day one, the Biden administration halted all deportations for 100 days. This was followed by President Biden's executive order on restoring faith in our legal immigration systems and strengthening integration and inclusion efforts for new Americans. The order required DHS, in conjunction with DOJ and the Department of State, to identify barriers that impede access to immigration benefits and to find fair, efficient adjudications of these benefits and make recommendations on how to remove these barriers, thus creating the battle cry of the administration: removing barriers to mass migration, no matter the legality. To that end, Secretary Mayorkas issued a memorandum entitled Guidelines for the Enforcement of Civil Immigration Law, which outlined the appropriate instances in which DHS was authorized to take action against aliens either unlawfully present or lawfully present but removable. While in theory this would seem to encompass many aliens who should probably be targeted for enforcement actions by ICE, in reality, the numerous carve-outs, loose definitions, and required factors for consideration made it nearly impossible to move forward with most enforcement actions. These poorly defined categories could be seen to give even the most serious of criminal aliens a free pass in the interest of equity and justice. The administration has engaged in numerous rulemakings aimed at so-called efficiency and expediency at the border. These regulatory efforts focused on border processing and on immigration court procedures have been haphazard, creating more confusion at the border, and are largely in direct conflict with congressional action, a clear violation of the Chevron doctrine. These regulatory actions that purport to be tough on illegal border crossers more likely incentivize than deter aliens. The actions render moot anti-fraud measures and upend the congressional determinations on the credible fear process itself. Even more concerning, these actions put pressure on immigration judges to conclude cases quickly while simultaneously eroding ICE's critical role in the immigration court process. The intended result is non-adversarial immigration court hearings where the presumption always favor the alien seeking relief. Lastly, the parole abuse continues to be a tool in the Biden administration's arsenal, as unlawful mass parole programs have played a large role in artificially decreasing numbers along the southwest border. Categorical parole programs flagrantly disregard the plain language of the statute, which unambiguously limits parole to case-by-case matters and for very specific reasons. The results speak for themselves. Removals are the ultimate measure of effective immigration enforcement, and the numbers clearly demonstrate the stunning decrease during this administration. ICE has removed aliens at a rate of 3.5% of the aggregate number of encounters, compared to 32% during the previous administration. As for border encounters, under the current administration, Customs and Border Protection has recorded more than 8.5 million encounters at America's borders, including more than 7 million at the southwest border alone. As each memorandum, regulatory action, or policy decision is announced, the crisis at the southwest border grows exponentially. The system has been brought to its knees, and the administration does not appear to be slowing down. One thing is clear: this is all by design. These actions have created instability, not only for national security, public safety, and the economy, but for the aliens themselves, who are allowed to remain in a quasi-status that is far more akin to limbo than to lawful status under the Immigration and Nationality Act. The efforts undertaken by the administration have simply undermined our system and need to be reversed immediately. I implore this committee to continue its investigations and to take all necessary actions to ensure that the laws are faithfully executed and enforced, that order and integrity is restored to U.S. immigration law. The Department of Homeland Security and the Department of Justice must be subject to aggressive oversight and be made to explain why enforcing the laws as Congress has prescribed is simply not an option for them. They must be made to account for their policy choices, and they must be forced to repair the damage. This country is unable to fulfill its critical humanitarian mission, nor fairly and expeditiously provide proper immigration benefits until this crisis is quelled. A return to the rule of law is long overdue, and it is incumbent upon Congress to demand that corrective action be immediately taken. I thank you all for your attention and interest in this matter and look forward to answering your questions.